Hello, everyone. I'm Srinjay, the convener of the Law and Tech Society 2023-24 at NLSIU. And on behalf of our society, I would like to welcome the audience and wish all a Merry Christmas and a Happy New Year ahead. Thank you for joining us for this lecture during this holiday season. I would begin by introducing the speakers for today. First, we have Ms. Mitakshara Goyal, who is the co-founder at Svarniti Law Offices. She heads the policy and advisory practice at Svarniti Law Offices. Her work revolves around analyzing contemporary issues pertaining to data, artificial intelligence, technology, and gaming, and energy laws. She has led policy research teams for representations, seeking amendments and clarifications to the proposed bills in the sector, or proposing regulatory frameworks for unregulated sectors, such as gaming and virtual digital assets. She has delved into economics and policy at the University of Oxford, which entails detailed discussions on taxation laws and attaining Pareto efficiency from the perspective of India and other countries. She has been recognized in GAAR for her contribution in bilateral treaty investment arbitration, representing the government of India, strategizing recovery litigations for the public sector banks and NBFCs under SARFAESI Act, RDBI Act, and Insolvency Code. She regularly advises banks and financial institutions on data, technology, and privacy-related mandates, and a reputed market leader in technology on issues of self-regulation in the sector of cryptocurrency and data privacy laws, and also on issues of taxation and regulatory framework in the gaming sector. She is leading the policy-centric research on legislative proposals and amendments for two Indian-based companies engaged in online gaming from the perspective of constitutional law, taxation, as well as Prevention of Money Laundering Act, and also advises multinational organizations on their prevention of sexual harassment policies. Up next, we have Ms. Lognayaki P. Lognayaki is a legal professional and researcher deeply entrenched in the evolving landscape of AI, technology, data protection, and privacy. Currently, she is serving as counsel at Svarniti Law Offices in Delhi. Lognayaki actively engages in pivotal policy discussions and research centered around the ethical dimensions of cutting-edge technologies. Her academic background includes an LLM in constitutional law from CMR University, where she received the prestigious gold medal. She not only excelled academically, but also contributed significantly to various professing roles across different institutions. At present, she is also pursuing a PhD at Christ University, focused on leveraging the potential of AI to overhaul the Indian judiciary. Her research aspirations revolve around the strategic implementation of AI to streamline legal processes, effectively reducing case backlogs and optimizing judicial efficiency. Previously, she has refined her legal expertise at SRS law firm in Chennai, addressing intricate legal challenges and complexities. Her published works highlight her dedication to shaping and strengthening the future of legal systems amid the transformative tide of the digital age. She is deeply committed to ethical technologies, integration, and foresees a future where the seamless integration of law and innovation propels both societal progress and technological advancement. With this, I would like to move forward and would like to request some time off from the audience before the lecture starts, as we have an important announcement to make. It's that we have entered into a collaboration with Svarniti Law Offices, where we would be holding joint conferences, research projects together. And in case you are a part of the NLS community, there might be some internship opportunities coming your way from Svarniti Law Offices. So do keep an eye on our social media handles for future events, etc. I would now request Mitakshara ma'am to say a few words on our collaboration and then start with the lecture. Over to you, ma'am. Thank you.
Thank you so much, Indra. That's really kind of you for a really lengthy and not so deserving introduction. Thank you all. I see a great turnout. I mean, in the middle of the day, afternoon, having 130 people join, it's really overwhelming. And I'm looking forward that this number only increases as we go on with our collaboration. So thank you all for joining. So firstly, I'll just give you a brief background about Svarniti. So it has been founded by me and another partner. We both were working together at PNA Law Offices prior to this, after which we have founded Svarniti. I primarily specialize in BIT, which is bilateral investment treaty arbitrations, as well as policy. my general policy work ranges not only around AI, but also data privacy, gaming, uh, COTPA, and we advise the government on and off, which is why the opportunities for you um, come with us, which includes not only internship opportunities, which is of course every firm offers, but also collaborations with the government. So many a times we assist a lot of MPs in making policies and making policy proposals that would perhaps be tabled. We not only assist MPs, but we also assist the ministries when they are toiling with ideas pertaining to certain bills, not only bills but negotiations, the trade agreements. I have been in. I was a part of the negotiation of the UK India trade agreement. So anything to do with policy, not only AI. So while of course LTech has been kind enough to have this collaboration with us, but the internship opportunities or collaboration or writing opportunities, publications not only range from AI tech, but it also goes beyond into arbitration, dispute resolution, and anything to do with Indian policy, international policy, largely. And of course, we have Lognayaki, who is doing a PhD. So, should you guys have any aspirations in terms of PhD or publications, and you require the same for the LLMs, we are of course more than willing to collaborate with you, have those publications, and should you work with us in depth, I mean, if my recommendation as a ex-Cambridge graduate helps, I would be happy to do so. And I'm sure Lognayaki will join me in stating the same. So yeah, I mean, opportunities are immense. Shinjoy has our details, so we can. We are looking forward to a lot of collaborations, which might be just perhaps writing a policy proposal, or even if filing a writ petition. I mean, I'm seeing that litigation with respect to AI is not that active in India as opposed to US. Um, and I'm looking forward that a lot of us work a lot together in terms of litigation with respect to privacy concerns regarding AI. So on this note, of course, we can have further conversation on this. I would like to continue and start the presentation. So Shinjoy, can we start, or is there anything else that you would like me to cover in terms of
Yeah,
opportunities?
yeah, I think that was a lengthy details about whatever we had planned and what we are looking to go forward with.
All
And I
right,
think we can start with our discussion, but I can see Tushar has raised his hand. Can you just drop in a message in the Q&A or through the chat so that it's
sure.
visible and we can take it up. So if anyone has any questions during the lecture, you can drop in a message in the Q&A, and we'll take it up. And I
Sure.
think, yeah,
Hi,
I think,
Tushar.
yeah. So other than that, I think we can start with the lecture. And thank you, ma'am.
Okay. I think some people are seeking the contact details. So, Shinjoy, I'll request you that after this presentation, maybe you can sum up the lecture and also provide our details for
Hmm.
further collaboration with the students. Yeah, and any other questions with respect to collaboration, please feel free to write to me, and I hope that my office will respond ASAP. Yeah. So I'm going to start with the presentation, and of course we can keep having further conversations on this. So we have very strategically um limited our topic to not just DPDP, considering you've already had a lecture on that, but limited it to the idea of reevaluating consent and regulation of AI processes, especially in the framework of public available data. Yeah. So, just a second. Yeah. So, what is the whole idea of this lecture? Yeah. What are you going to learn after this? So, okay. So first would be, what is generative AI? I'm sure there's a lot of jargon around all over the web as to what is generative AI. So perhaps we'll just dumb it down for all of us. And of course, I'm happy to have your inputs as to what you think is generative AI. The second is, why is there a need to regulate generative AI? Why is there so much conjecture on consent? Where does the panic come from? And to what extent can you regulate this? Is it first is whether there's a requirement of regulation, but the second thing is, can you really regulate it, or is this conjecture just all in the air? Then we've Lognayaki will help us address some issues on GDPR, a comparative analysis on the regulation with respect to consent in AI, and of course, we will also analyze DPDP from the lens of AI, and especially public available data and the exclusion of the same. Okay, so first I'd like to, of course, question what is the hype about? Can I ask you, does anybody know any old generative AI, or when was the first time perhaps generally public encountered generative AI? Anybody? So I'm just going to see whether I have any. Shinjoy, I have a comment that somebody is not able to join. Just I'll leave that to you. So anybody who would be able to tell me? I think it'll be better if you all just unmute yourself and give the answer, considering I'm managing too many platforms. But I'll quickly give the answer. So before Midjourney, before Stable Diffusion, and all of these fancy apps came into place, we already were introduced to several others, and I'll come to it whether it was a new concept or not. But do we understand generative AI? What is the difference between the normal AI or probably a generative AI? Why is there a panic? And in 2 seconds you'll get to know. So earlier, the initial models that used to be there of AI used to be discriminative AI, which would essentially mean that I would train my model that there's a robin, there's a chicken, there's an eagle, and a turkey. All it could initially do is that when I feed in an input, it could determine whether it is a robin, chicken, eagle, turkey, or a flamingo. So it had a defined data set. It used to just do what it used to do is just compare my input to the data set that it had and see whether it fits into any other and identify that, yes, this is a chicken or not. That's it, right? There was no further creation or generation. It was only a prediction or a comparison. But what does generative AI bring? It brings a generation of a new framework or a new output which we would not imagine. So essentially what would happen is I will give a data set to it, which will of course be amalgamation of multiple text, multiple images. So it would not just compare as to what discriminative models used to do. It would perhaps create amalgamation of two images. What we these days are also seeing as deepfakes, right? Where I can paste an audio of Lognayaki, I can have image of mine. It will both be amalgamated to merge my audio, her image, and create a deepfake of her speaking my audio. So essentially, that would be generative, something that is not limited to comparison, but goes beyond to generate a future text. And how does it do so? It keeps learning and keeps storing what it learns in every data set. So my initial input creates an output, and that output is also its input for the next output. So essentially, it's learning as humans are learning and generating as humans are generating. What makes it dangerous is the unpredictability of the same. Right? So once you've understood what generative AI is, my question again comes: have you seen generative AI in a very less dangerous form where all the agencies and all the legislative bodies were not really worried about? I think this is another example that I've put up that you will see where, of course, there's discriminative model where a dog could only detect whether it's a dog or a cat. However, in a generative model, an input of a dog could create a new output of a dog, which is a different dog, because it's learning. It could be a possibility that a few features of this dog was initially inputted, and amalgamation of many data sets could eventually lead to this result. Yeah. Now, again, coming to the same. I'm not receiving many answers, or in fact, I am. I would come to the first type of generative AI, which didn't flag many agencies, and that is Google Translate. That was one of the initial forms which came in 2017, which essentially required us to input a data, and the output was very different from the input. So this was one of the initial forms of generative AI. I didn't flag the agencies because there was not much of my personal or private data or my publicly available personal data that was being used. And that's why perhaps the legislative agencies were not that concerned about it. Then eventually the evolution came, and there was Siri. There were many conjectures as to whether Siri is listening to me. Is it collecting all my personal data? Yeah, I mean, it became a friend to a lot many people, but at the same time, besides being a companion, was Google and Apple also listening to my personal conversations? There has been a lot of conjecture on this. There have been papers which do state that Amazon was sued for the same, but it was found that there were cookies and there was my browser history and my searches that were being stored. So those were initial forms of generative AI, from translators to Siri. And then we are, of course, evolving further. And before I, of course, go into consent, and before I go into the risks involved, um, I want to show you all a clipping which sort of shows how generative AI works, where a picture of Obama and, of course, audio of another individual has been amalgamated to generate something. So as you all saw, the person's audio and Obama's picture was eventually amalgamated. It seems risky, right? But then again, now I'm going to ask you, what is the conjecture on consent and privacy? So can anybody just tell me which one is
Excuse me,
the...
ma'am. Some people are saying that you are not audible.
I'm not audible, is it?
Can
Sanjoy, can you hear me?
I can hear you. Like, can someone confirm?
She
The
is
video
audible, but then they mean the video that is being played.
Oh, I
Okay.
don't think that they have. No, then it's all right.
Okay.
And yeah, in case anyone wants to speak, just raise your hands and I'll just open up the mic.
Okay, I'll try to replay the audio once more. Okay. Is it audible?
It's not.
That's our bad luck then. So I'm going to move forward. It's essentially amalgamating the audio of the person with Obama. I'll share the slides with you all so you can see it afterwards. Now, can any one of you just say right or left and then just raise your hands to tell me which one is the deep fake here? Or is either of them deep fakes? I'm going to look at the questionnaire. The left one is the deep fake. Is it? Can I have more answers? I'm sorry, I'm having to display the questionnaire, so I don't want to do that. But okay, I'm just going to project. Considering for me, both looked identical. Of course, one is a deep fake and one is not. Of course, it's not visible. Since you're put on the spot to, of course, identify the one of the deep fakes, of course, you look at it in that fashion, right? So again, this of course raises concerns as to what could deepfakes really do in terms of morphing in pornographic content or even in elections. I mean, there was a conference where Ms. Madhvi Diwan, the ASG, talked about how AI could be used and misused during elections in multiple cases. Are we being misinformed? You've seen Donald Trump's images that were of his arrest, which were, of course, produced through AI. There was disinformation on bombings, on the Pope wearing a jacket, which was not him. So, of course, these are conjectures where, of course, AI is being used in pornographic content during elections to defame people. And this could be a problem, right? Which is why the whole conjecture of consent comes into place. But the last, unfortunately, again, I think you all will not be able to see the clipping, but this is basically about Synthesis AI. Synthesis AI, like ChatGPT, is again a generative AI app. But what it does is it clones you. So today I can create a clone and give a video lecture to you without actually having to give the video lecture. So it could be a pre-recorded lecture where you will not at all understand whether I'm physically giving the answer. And of course, technology is advancing. So eventually there will be more nuanced technology that will come in and make it more realistic and hyper realistic as we go forward. And of course, this poses a lot of dangers as we also get convenienced by it. So, Lognayaki, can you tell me whether this one is audible? No?
Mitakshara.
Okay, there's some issue there. But no problem. So, just a second. Can I just take a minute, perhaps, to figure this out?
Yeah, sure.
Okay. I think this should be audible now.
Bank
Is it?
biometrics. Instead of asking
It is
security
audible, yeah.
questions, some banks use your voice to confirm it's you before transferring you to a customer service rep.
This call will be monitored and recorded, and your voice may be used for verification. Please state your first and last name, followed by your mailing address.
Joanna Stern.
Thank you with Chase Credit Card Services.
It worked. Chase confirmed the voice and put me straight through to a service rep. No additional questions asked. Later in the day, I asked our intern Slav to try to do his best impression of me to see what would happen.
Please state your first and last name, followed by your mailing address.
Joanna Stern.
This is on the signature panel on the back of your card.
See, in Slav's case, the voice biometric system didn't buy it. It asked for further verification. When I reached out to Chase's spokeswoman said, "We use voice biometrics along with a variety of other methods to authenticate
Even the lady
customers
who is
calls,
speaking is
which
an
act
AI
as a
bot.
complete
It's not the
request
real
customers must provide additional
lady.
information." Challenge 3, pass.
Okay, so basically the idea was to show you that AI will not only breach voice modifications or voice bots, but also eventually lead to a lot of data breach, data threats, and even banking threats, right? So there can be financial frauds, etc.
Bank biometrics.
So what is the legislation doing about it? Do we have enough legislation for it? So let's deal with that. So we've looked at a couple of risks, and we know that consent is required. I need to give consent to the information that is required for data set. But does my DPDP Act require that? So we come to the issue of consent. And what does DPDP require? The DPDP Act has categorically required consent for the utilization of my personal data. Now, how do I give consent? There'll be a notice provided by any entity and any organization who is using my private data. I have to respond to it in clear affirmative terms, perhaps provide a written confirmation. They have to also provide me with the specific purpose for which my data is being used. And of course, it is a given that it has to be for a lawful purpose. And it is only upon my written clear confirmation could it be used for only those specific purposes. Now, understand that this is the consent-based model. There are, of course, other models, but which is not envisaged in DPDP, but there is the opt-out model where you can opt out of giving certain kind of information or deletion of your data after the specific purpose is being used from the organization's data. But right now, I'm just going to stick to the DPDP. So the only mention of consent per se is in the context of private data, personal data for specific purpose, as you can see under Section 6 and Section 4. Yeah. Once the consent has been given by the data principal for private data, and it is provided to the organization, we will see how AI could also breach that. But that is a secondary question. My problem is what happens to my publicly available data. Now, another issue that we'll discuss is the term publicly available data defined? And that is my primary question. When the DPDP Act makes that exclusion under Section 3, which is on the applicability of the Act, you will see under subsection C2, the personal data is made or caused to be publicly available is excluded from the requirement of consent under the DPDP Act. Or rather, the entire applicability, which also suggests that the sanctions, the penalties, the forum, everything is excluded from the applicability when it comes to the publicly available data. Now, my issue is that there's no definition of publicly available data. And that could be really vast, right? As they've given an example of social media and your image on or views on social media. That is only one part of it. But what happens to anything that I enter today on email or on a server or on a healthcare website or even on an MCA website, right? Does this mean that that's publicly available, and to what extent? That there is complete uncertainty on that, right? We'll come to see that how AI really uses our data and could use our data, which DPDP does not fathom at all. So not only is DPDP entirely silent on what artificial intelligence or generative AI could do, but it is also silent on the very scope of its non-applicability, which is the personal, publicly available data of the person. Now, with another aspect that I want to flag under this section is the personal data that is made or caused to be made, right? So one is me voluntarily posting a picture on Instagram, which would perhaps be, I have made it available. But what is caused to be available by me or by any statutory authority could be literally my financial data that I put on an email, or I could put on the passport services website, or I could put on MCA, or perhaps the banking websites, right? So essentially, whatever I'm caused to also produce publicly, and when I say publicly, it means on the web, really, because for the purposes of AI, because considering there would be eventual web scraping that I'm going to come to. DPDP takes a very simplistic stand. It has not even considered the whole scope of web scraping and AI and reduces the whole consent to just personal data that I would perhaps give for specific use, but does not even contemplate what happens when I give any data on web. Does that mean that it converts into public data? Perhaps no, for DPDP. So it has really a short-sighted, myopic view of what publicly available could mean. Perhaps what it meant was just putting things on social media, or putting my views on a blog, or putting my views on Twitter. But what it doesn't realize is that the AI apps or OpenAI or companies like Google have manipulated this term data publicly available to essentially web scrape, to essentially read emails, to essentially scrape data from your social media or your location services, right? So we can totally understand that this DPDP Act is very premature and is of course not nuanced to consider generative AI at all. Now I will eventually come to another discussion as to whether the consent model that DPDP envisages or contemplates to be the correct model, is it even efficacious when it comes to AI? Or could it be efficient in the cases of AI? Or do we need entire legislation altogether for AI, separate from a consent model DPDP? So keeping these thoughts in mind, I'll go forward to what you think is public and personal data. And as I discussed, there could be many versions of it. For OpenAI, my emails or whatever I put on web could also be personally public data. But do we really think DPDP Act and the legislative agencies who built this DPDP Act contemplated that? I doubt so. it took a very virgin approach of what publicly accessible data would be, which would be presumed to be just data that was provided by us voluntarily on social media. Now here, I was suggesting the surreptitious use of data gathering that have been repeatedly used by Google, by OpenAI, by so many others, Stable Dissolution, all of these. I mean, I'm sure you all would have seen several notifications on how Google has actually faced a class action suit, not just a lawsuit, but a class action lawsuit for web scraping of not only your data on social media, but also on Gmail. So essentially, whatever you are sharing over your email, which essentially would be your personal data, is also being scraped by for the learning of Bard, for Cloud AI, Google Translate. And it has very recently also changed its privacy policy to remove Google's language, because earlier it was only used in the context of Google Translate. And it has changed that, it has removed the word language and added AI models, essentially seeking consent to scrape any publicly available data online for training of Bard and Cloud AI, right? So you would say that, why don't I just delete all my Gmails, right? Why can't I just delete all my social medias today after this presentation? We will see how generative AI works in such a fashion that the deletion requirement would really be a waste. And that's what Google, OpenAI are capitalizing on. And that is what our legislative agencies really need to understand and create a legislation or a regulation for it. Similarly, with OpenAI having the same kind of lawsuits for ChatGPT, and Meta faced the same thing. Now, I want to talk about what additional ammunitions could or are being used against generative AI. So one, I've talked about how there's lack of privacy, right? Data privacy protection in India. And of course, while there are other laws, and I think Lognayaki will be addressing the comparative legislations, there has been, of course, conjecture as to how they are also insufficient. And we'll come to whether the consent model is really insufficient. But what else is happening, and why consent is still the primary issue with these other with these other ammunitions as well? So one is the IP violations. Does anybody have any idea as to what is happening with IP violations when it comes to generative AI? Anybody? Okay, so I'm just going to take a lead here. So there have been several users.
I think Chaitanya wants to speak.
Okay, great. Yeah,
Chaitanya, go ahead.
Am I audible?
Yeah, you're audible, Chaitanya.
Yeah, so as far as you know, there was a case against Facebook about it, like Facebook versus Power Ventures, according to which I think publicly, like scraping data which was available on Facebook's websites was considered to be a IP violation of Facebook. Just because I think the website was considered to be a part of Facebook's intellectual property as per the terms and conditions. I think this holds for all social websites.
Okay, thank you so much, Chaitanya. I think I will take that lead of yours and actually expand on this. Okay, now tell me something. You have written an article and you've published the same on the web, right? Now AI picks that up as a data set in the web scraping without your consent, and modifies that article and creates a new generative article. Now, could that be considered your violation without your consent? Again, the consent is a primary figment in this entire AI sphere. There have been users, there have been artists, especially, who have sued the AI companies, apps against generative AI providers. And of course, with their copyright and patent claims. Since AI apps like Midjourney, which creates or synthesis, what they do is they collect images, web scrape images through LAION, and they create further images or advanced abstract art. I'm sure you all have seen Midjourney outputs. Since they are inspirations of the copyrightable material which is on the web, again, publicly available, yet my copyright, but they have been taken as an inspiration without my consent. So does that lead to me having a claim against generative AI? The UK courts have refused to say. There's not much jurisprudence on this for India, but there have been such cases in the US and the UK, and the district and the Supreme Courts have been reluctant to suggest the same. And the primary reason is that they say that most of the art is inspired by somebody or the other. How can we sue a generative AI app for generating something which is inspired by an image? And who will you sue? At the end of the day, it is an uncontrollable AI model where the companies themselves after a point don't know what is the source, right? As I explained to you in the beginning, an input will lead to an output, and that output might be an input for the next output. And it becomes so complex. Of course, while I'm dumbing it down, I'm sure you all understand that this is way more complex than it seems. And after a point, you really don't know the chain of source when the output comes in, right? So there is no way to find liabilities anywhere when it comes to generative AI, and copyright violations, as soon as you put it on web. And on the other hand, the output size, Meta AI have actually requested for copyright on certain books that they have generated after taking inspiration from copyrightable work. And the courts have also denied that. So Meta AI did not get copyright on their AI-assisted products or AI-assisted outputs, considering AI copyright or IP rights have generally been limited to humans. I mean, I'm sure you all would have, you know about that monkey case where a monkey selfie there was a whole lot of lawsuit and litigation on whether that monkey or the chimpanzee owns the selfie that he clicked. And of course, the decision was that only human-made or human-created art could really be copyrightable or patentable. So again, I'm coming back to consent, considering there's no way for me to give consent when it comes to web scraping. And does DPDP really envisage any scope of web scraping or any situation where web scraping would be penalized? No, not at all. Okay, similarly, this is another IP creation. Could any one of you tell me so Quint claims that somebody wrote on ChatGPT, please get inspiration from Rabindranath Tagore's poem and create another poem. So one of these poems are AI generated. Could any one of you tell me which one of them is generated by ChatGPT? Anybody? You guys can give a shot at it, because for the longest time, I did not know. I'm sorry, I'm left to generated. Okay. You all are really smart, because that's the right answer. So the black text, the white text and the black background is the AI generated poem. And again, the question comes in, can ChatGPT today seek a copyright on this poem? And the courts abroad have, of course, refused the same because of the machine aspect or a non-human creation. But also raises concerns for the artists and the creators as to whether what happens to their rights and the violation of their art, and of course the monetary effects of those, or the lack of thereof, in fact, of not having such protection when it comes to AI. Now, I want to ask, can we have license as a consent? Most of the AI professionals have suggested that license could only be for a single use license, right? I can give you a consent for license for one-time use. But as I again discussed, once it becomes an input for one generative AI, you really can't stop the program from reusing it and reusing it. So there is no way for me to enforce my license a million times, because it will recreate and create so many versions of that image. The IP itself will lose value of the same. And this itself is a concern for several artists or several writers, right? So what do we do? Do you think the consent model is a concern? Anybody? I sent you guys a joint proposal statement where they've discussed the whole idea of consent and whether consent model itself works. So anybody, before I hand it over to Lognayaki? So I'll come to it. The problem with substantive model of consent model in the AI generative space, and why I think the DPDP consent model itself is not in sync with generative AI, and we would perhaps require an entire framework, a separate framework altogether, is because what will be the proposal? The proposal would be that you seek consent from an individual, and then you suggest the purpose, the specific purpose for why you're using that information. And we cannot really do so in generative AI, right? Once you've given that information to a data user, which would essentially be Meta, Google AI, Google, OpenAI, etc., that comes on the web, once it's publicly available, then your personal data is no more subject to consent terms. Once it's on the web, when it's on the common web, the common crawlers will pick it up. What is common crawler? It is basically a software which does mass web scraping for ChatGPT, for OpenAI, for Meta. Once that picks it up, there is no way for you to determine who is the next data user and for what purpose it's being used eventually. I could give consent as a license for one specific use in one exhibition or to create one generative AI, but it's never going to be possible for me to follow the same. Similarly, some people have suggested an opt-out option. There is a AI, AI model, I think, which has created a website called Have I Been Trained, which essentially allows you to opt out of that data set for their generative AI. But that's really just a figment of imagination, because once you put it on the web, once I put it on ChatGPT, there's no way for ChatGPT to remove that image or opt it out. And similarly, deletion. Can I backtrack and delete the information I've provided on generative AI, even if it had that system? I really don't think in any imagination could you really delete it from the server or from common crawlers, which is essentially a larger web, a dark web sort of a thing, which web scrapes. And the problem is that most of these organizations have been very reluctant to tell their sources. When Google was in the lawsuit asked about its sources, its answer was, we have taken information and trained our Bard or trained ChatGPT from Common Crawl, or LAION, which is essentially softwares which scrape data. So it's really not giving us any information as to what is the source, right? So how do we opt out? How do we delete? There is no way about it. So does that mean that there is no consent model that could perhaps be viable for generative AI? In my opinion, yes. But then what do we do about it, right? I mean, of course, I would leave the rest of the discussion for Lognayaki, but just to give you a food of thought, that perhaps we need more sanctions on such companies. Perhaps we need a better data privacy model in which the companies are imposed with more sanctions on how they are using data, considering the data principle has no role to play once it gives consent in any fashion, right? So while consent, even in we have a whole discussion. I mean, of course, it's not scope of the presentation, but we have been discussing a lot how the consent model, even for personal data, is a problem. But I'll leave it to another day, maybe another presentation. But just think about it, how we can impose more sanctions and how a new framework can be developed. And of course, in our we are doing a lot of work on EU AI Act. It is not scope of this presentation, but we're going to analyze. I think Lognayaki and I will be analyzing how EU AI Act has really done justice when it comes to privacy and generative AI. Over to you, Lognayaki.
Excuse me, ma'am. I think there are some questions on the chat. So I would be reading out. Lavina is asking,
Can I
can
request that? Can I request that she just finishes her bit and then we can take it collectively?
oh, okay, no
Yeah. So
issues.
just a flow will break. Yeah. Okay.
Oh,
A very good afternoon once again. Am I audible? And yes, the PPTs are visible to you. So if you can confirm again if my voice is audible. Yeah, so I can see a thumbs up. So I thank, I can see 168 participants. I thank you all again for having joined in for this session. So Mitakshara has very well explained, I would say in simple terms, as to what is generative AI, what is ChatGPT, what are the various generative AI tools that are present. Now, when you talk about generative AI, the one main term which needs to be addressed is LLM. So people who know about LLMs or any of these technical words, maybe I'll ask a few questions and then you all can answer it later to me or type it on your chat. Anything works. So when I talk about LLMs, so which is nothing but large language models. Now, when I say GPT, which to put in simple terms is generative pre-trained transformers or transformer from OpenAI. So these are most advanced AI systems. So they are basically developed to understand, generate, and interact with human language in a very coherent and in a contextual manner, in a very, very relevant manner. So what they do is they all dwell on large sets of data. So only thing that they require is data, right? So any data that which is available online, they scrape it. Now, I guess you all must have gone through certain of the PDFs that were shared by Shrinjoy last night or this morning or this afternoon. So if you want me to talk about web scraping a little bit more, maybe at the end of the session, I'm sure you know what web scraping is all about. And in simple terms, like Mitakshara has already put it to you all as to what is Claude, what is Bard, what is ChatGPT, and various other AI tools. Maybe I've missed out on Llama, or if you do know about various other tools, you all can type it on the chat. Okay, so then talking about the DPDP Act 2023, Mitakshara has addressed certain of the important provisions when it comes to what basically is consent. So I don't have to tell you all what consent is, right? So you know what is consent, which is defined well under the DPDP Act 2023, and also about the exception or the exclusion when you talk about the publicly available data, which is not addressed by the, or which is not regulated by the DPDP Act. Now, moving on to this slide, in flow to what was previously mentioned by Mitakshara. So now talking about balancing AI's potential with data privacy. Now here, when you travel the terrains of artificial intelligence's immense potential, while safeguarding data privacy. Now, this is very, very delicate, which needs to be balanced well and addressed. Now, when you talk about the essence of this challenge, what exactly is the challenge? It lies in addressing the need for stringent data protection regulation. Now you can ask me, there is already a beautiful legislation, a beautiful piece of legislation, which is laid out in the form of DPDP, and the Indian government has done a great job in coming up with this particular act, where various other countries have failed or still in a very beginning stage of not having created an act for data protection or privacy for that matter. So here, especially concerning the lack of explicit consent and the covert nature of data collection by AI systems. Now, when I say covert nature of AI systems is what, when you do not get consent, when you do not get consent from whom? The data principal. When I say data principal, here I mean the data subjects. So talking about the terms mentioned in the DPDP Act, we have the data principal, we have the data subjects, right? So data fiduciaries. Data fiduciaries are the ones handling the data of the data principals when consent has been explicitly been given. Now lies the problem here, if you can focus. Now, the recognition that informed individuals and the data control are very, very paramount. When I say you are a data fiduciary handling a person's data, so you will have to get what? A consent, and a notice will have to be given to them stating that this is how I would be using your data, for what I would be processing your data, and all of this. So you need to empower these data subjects. When I say data subjects, the data principals, about the collection, the storage, and the utilization of the personal data, which is very much fundamental when you come to talk about the DPDP 2023. There's no doubt about it. It is not just about transparency, but also, the agency which is given to the data principals to manage their data in the AI-driven ecosystem, like we all put it. Now, in this particular context, the regulatory framework, yes, is very pivotal. It is playing a pivotal role, there is no doubt. And compliance with this act becomes crucial for both AI developers and the users, right? Is the DPDP Act addressing it? Yes, very well addressing it. There is no doubt about it. Now, the DPDP Act, if you see, it actually stresses upon the importance of informed consent. You are not denying it. I am not denying it, right? So it underscores what? The individual data rights. My data, my rights, and specifically addresses what? The privacy concerns associated with AI. This we do not deny at all. Now, by mandating such consent through the provisions under the DPDP Act, we know it aligns with the essence, be it with AI practices, ethical AI practices, ensuring that the data principals are aware of how their data is being used. Yes, it establishes a foundation for such individuals, right? Okay. To assert control over their data. Now, I have control over my data, so I will give you permission as to for what it is being used, right? Now, Mitakshara, can you go back to the previous slide talking about the dilemma, right? The previous slide, which speaks about the consent dilemma in AI. Now, addressing the lacunae part, which was already discussed by Mitakshara. So, under this particular dilemma, in the DPDP Act concerning the AI-related data processing and collection presents a significant challenge. Now, let us address the particular challenge. Now, what is one such glaring issue which we need to discuss about, which is nothing but the publicly available data, which is not regulated by the DPDP Act. Now, the scope of the act, coming to the scope of the act, it does not comprehensively cover the intricacies of AI-driven data processing. It only says you want my data, or whosoever is collecting my data, be it any AI firm or be it any AI organization, before processing data, it needs to get what? Consent from the data principal, right? That is well agreed. But then where does this lacuna lie? Now, the lacuna here being these ChatGPTs, these generative AIs, these AI tools, they web scrape, right? So they do web scraping where the user, say, for example, the data principal is not aware of how their data is being utilized, or in the first place, they do not even know whether their data is being scraped or not, right? So this possesses a significant obstacle in obtaining informed consent. Now, this gap in awareness, let's say, it impedes the user's ability to make informed decisions about the use of personal data. Right now, talking about Section 3C2 of the DPDP Act, which was shown on the slides to you all, adds to this dilemma, right? So this intentionally, whatever is intentionally made publicly available by the data principal, there creates this exception. So this grants AI firms the flexibility in accessing and utilizing the publicly shared personal data, such as content that is posted, let's say, for example, bloggers, food bloggers, travel blogs, law blogs, or whatever blogs that are available on social media platforms, right? Now, say, for example, I post a photo on Facebook, which is publicly made available. Do I want the photo to be misused and exploited by any person? Do I give permission for that? Is there a consent present for that? It is still sensitive. It is still a personal data which is not regulated by the DPDP Act, is what we are trying to state. Now, while this exception might seemingly facilitate the free flow of information, right? It is free flow of information for AI development, for training these LLM models, right? For developing these LLM models, it raises concerns regarding what? Control and consent. The Act's provision indeed leaves a gray area where individuals' data shared intentionally, but not fully comprehended in its potential usage by these AI systems, right? So thereby there is a very blurred line or a blurred vision of informed consent and control over personal data. Right now, we have gone through the landscape. We've traveled through the terrains of how AI or these AI tools are scraping the web and consuming on all these data to train their models. We've seen all of this. Right now, this diverse array of data types, it could be in the form of texts, it could be in the form of images, numerical data, which was already shown to you all by Mitakshara, right? So it can be any kind of database or sensor inputs, right? Anything, providing a rich source of information for these AI systems. These AI systems are what? Waiting for such kind of informations to be fed into their systems to be trained. Now, however, concerns have surfaced regarding the manner in which AI collects and analyzes the information, particularly when it involves data scraping without explicit user control. Right now, here, while this particular provision may seem, say, very conducive to the AI development by
Lognayaki, can I just request you to just inform them what GDPR is, just a brief for you?
Yeah. So once I complete DPDP, then they will get a hang of what GDPR is. So if once I cover what our particular provision says, and then we can move on to GDPR and how publicly available data is being addressed by GDPR. So there would be a flow, right? Okay. So here now, there is an absence of stringent regulation, I must say, because oversight specifically addressing this aspect, the concerns surrounding data privacy in this particular landscape is of much importance, which needs to be addressed and calls for stricter regulations. I'm not saying we need to have another act altogether. All I'm saying is we need to have certain amendments which can also have in place or keep in mind web scraping or AI feeding in a lot of data. So there's a growing demand for such legislative amendments that emphasize stronger protections for individual privacy, ensuring that AI firms operate within these ethical boundaries and prioritize user consent is what I'm trying to say. Now, how do we address these gaps? Right, I did tell you that there is a pressing need for legislative amendments to address the intricacies of AI interactions with such kind of data, right? Now here, these amendments must explicitly incorporate provisions that specifically addresses the nuances of AI's engagement with publicly available data. Right, that is one thing that the amendments must focus on. So thereby these amendments should mandate what? AI firms to obtain user consent in the first place, acknowledging the individual's right to be informed. Now, right to be informed is, okay, now you all tell me, this is a question posed. Maybe if you all want to answer it in the chat, you all can do so. Right to be informed, is it mentioned in the DPDP Act of 2023? Just say Y or N. Yes, yes, Y, no, N. Anything is fine. You all can just type in yes or no. Right to be informed. Anirudh says no. Juhi says yes. Akash says no. Avidal, Rahul, okay, yes. Okay, there is a mixed answer, but the right answer would be no. It does not answer this particular aspect where there should be a right to be informed, right? So this is actually addressed by GDPR. We'll talk about GDPR a little later, right? Now, transparency and disclosure requirements form what? A bedrock of responsible data deployment or practices, because there has to be transparency and there has to be disclosure, right? Even be it publicly available data. So now talking about the challenges, can we go to the challenges in the consent model? I'm sure
We're slightly short of time, but yeah, I'll just.
Challenges in the consent model. So now talking about the conventional consent model, so there are significant limitations to this. We've spoken about enough limitations about the DPDP Act, right? Now a fundamental obstacle, talking about the obstacle, arises from users' lack of awareness regarding the intricacies of their data processing by AI system, right? There is no awareness. There is a veil of opacity, I must say, right? When it comes to AI gathering information online. So this opaque nature of AI driven data to provide informed consent, as they lack insight, right? So when I do not know when my data is being scraped, how am I to give consent? So that is one such challenge which needs to be addressed. So now moving on to the next slide. So here in this intricate web of data integration with AI, the prospect of retroactively withdrawing consent possesses a significant challenge. Now, y'all quickly tell me, yeah, Juhi says, ma'am, but as per my knowledge, there is one clause in the act which says the data principal should be made aware about the usage of data, right? That is a whole concept of DPDP Act, but the concern here is when it comes to publicly available data, right? So here, what I was trying to say here is that, yeah, so there is one such provision in the DPDP Act that a data principal can withdraw his or her consent anytime when they feel that their data must not be processed any further, right? That particular provision is addressed by the DPDP Act, right? Okay. Now, you tell me, maybe at the end of the session, we can have this fruitful discussion as to if I am voluntarily providing my data to these web scrapers or to these AI firms or organizations, right? I said after having been given consent. And these are merged within the web of AI. Now, if I want to withdraw or erase my data, can I do so? Please have this question in mind. This is actually very, very important when we talk about AI. Once you have given your data voluntarily, can we actually retrieve it back is what the question is, because as per section 12 of the DPDP Act, there is a provision on right to correction and erasure of personal data, right? A data principal shall have the right to be it correct or update or erase data. But when it comes to AI, when AI has taken data from you, and when the data principal wants to retrieve or take back or erase the data, will it be possible to do so? Please have this question in mind. We can discuss this later in the Q&A session, right? Now, and I also want to know something about opt-out mechanisms, which has already been discussed by Mitakshara. We'll talk about that as well, right? Now, here, there are certain mechanisms, there are certain suggestions maybe from our end, right? Okay, 1 second. Yes, ma'am, we can withdraw at any time we feel there is inappropriate use of our data, but specifically for AI, there is no as much mention as per my knowledge. Even if there is no mention as such, this is by whom?
Excuse me, ma'am, you are mute. You are muted.
It just went mute, no? Or
Yeah. Now you're audible.
it's okay. So like Juhi mentioned, it's when it comes to AI and when it's making use of the data, when I give the data, it is lost in the trance. Nobody can retrieve it. Even the data fiduciary who is handling the information will not know where the data is in the entire trance of AI. When the LLMs are getting trained, you once lose your information, or once you give the information, or once it is scraped, once lost is lost. You cannot retrieve it. You don't have the right to take it back. You don't have the right to ask for erasure. You get it, right? So here, there are certain, okay, now also keep in mind certain technical terms, which we'll discuss later, because I want you all to answer it. I don't want me to be, because I'm sure you all being in the tech society, or you all must have come across all of these terms. What is data anonymization? Keep in mind, what is data anonymization? If you all want to type it down on the chat, it's fine. If not, later we can take it up by whoever wants to answer this, right? Okay, now data anonymization is one such practice which can be implemented, which can be used or served as a potent tool in mitigating risks associated with individual data exposure. So please, if you do know what is data anonymization, well and good. If not, if you want to type it down in the chat box, it's fine. So when there is a data, it belongs to me, right? So what you do is you encrypt your data. So when you encrypt your data, nobody will be able to access it. Only the people who are handling such information, let's say me and Mr. X is handling the information. Nobody else apart from the both of us will be able to use the data, view the data, handle the data, right? So that is one such suggestion, maybe from our end, right? So data anonymization is a wonderful potent tool, which I would say, right? So now here we could have, let's say we have the data protection board, right? So, and the inclusion of AI experts, we can have experts on the data protection board. They are specialized knowledge, could aid in understanding the intricacies of AI or whatsoever. And we also have DPIA, data protection impact assessments, right? So that needs to be a prerequisite. That needs to be a prerequisite for AI projects, which is also essential. So these DPIAs enable AI companies to identify potential privacy risks. So they will be able to, develop strategies and form a risk mitigation or management. on the whole, right? Okay, and there could be regular audits, compliance checks, continuous monitoring aligned with the international best practices to constitute a comprehensive strategy as a whole in the DPDP Act, right? So here we've understood as to what is DPDP, how it tackles publicly available data, where is the lacuna, what it must do, or we have also given suggestions to the same. Right now, I did mention about the right to be informed, right? Okay, now let's move on to the next slide where we talk about the comparisons. I'll take another few minutes and then we can wind up on the session and then move on to the Q&A. So talking about the consent in GDPR, right? Now, if I'm not wrong, we have Article 6 in GDPR. It speaks about lawfulness of processing. Yeah, 6, okay. Processing shall be lawful only if and to the extent that at least one of the following applies. And what is that one of the followings? The data subject has given consent to the processing of his or her personal data for one or more specific purposes. Here it says given consent. Fine, that's the same kind of a provision is present in DPDP as well. So when the personal data comes from publicly available sources, the data subjects must be notified in line with Article 14. Now, what is Article 14? Here it addresses publicly available data, unlike the DPDP Act, which explicitly says we do not regulate, the Act would not regulate publicly available data. See here, Article 14 actually focuses on the principles of transparency in instances of data being collected indirectly, right? Example from a third party. It's not a direct collection of data, it is indirectly collected. In such circumstances, the controllers need to provide information. When I say controllers, I am talking about the data fiduciaries. So, and to provide information to data subject at the point of collection or immediately following. So you get it, right? So here, when I talk about informing, the right to being informed when it comes to publicly available data. So here, we do know if personal data is not obtained from the data subject, he or she must be provided the information within a reasonable period of time, but at least after a month. This I'm talking about GDPR's provision, which is mentioned this, right? So in case where the gathered information is used to directly contact the data subject, he or she has the right to be informed immediately. So this we know. Right? So here, when it is publicly available data, the data subject has a right to be informed in a very precise, very transparent and a comprehensible form. This obligation is a must to inform and, which is to be fulfilled by the data handlers. This is as per the GDPR, EU GDPR, right? Now, moving quickly on to the UK GDPR so that you understand it a little better. Next slide. So we would only be discussing about UK and Canada, and then we'll wind it up. So just to make it very simple and addressing on just the publicly available data, can we collect personal data from these sources, including social media? Now, I must say, the UK GDPR, it actually does not stop you from obtaining and using personal data from publicly available sources. Let's say now we have political campaigns. Right now, these deep fakes, these political campaigns. So all of this were in trend, if I must say, along with Rashmika Mandana's video, right? So however, you should not assume that data protection law doesn't apply because the data is publicly available. One must not assume such. If you process this data, you become the controller. You are processing a data, so you become a what? A controller for it, and you must ensure that you must comply with certain of the provisions, the UK GDPR. For example, let's say the transparency requirements of the UK GDPR apply. This means you must comply with the right to be informed and ensure that you provide people with privacy information. This is a must when it comes to UK GDPR. I quickly have a small example for you. Let's say a political party, right? We have a political party. It sets up a page on a social media platform, right? Just go through with me on this. I'll narrate it to you very slowly. Right? So there is a political party. It sets up a page on social media platform. You get it. Now, the purpose of the page is to encourage followers to support the party's aims and understand more about the types of people who follow the page, so they can better target the campaigns. You get this. The party subscribes to the social media platform's conditions of the use of page, including their cookie policy and access an administrator. You get this. So the party subscribes to the social media platforms on these conditions. Now, for the social media platform places a cookie on the computer of those who visit the page. Say both users and the non-users of social media platform. Now, what does this cookie do? This cookie actually feeds back personal data to the social media platform that helps the platform tailor its advertising services across its platform. The platform has also feeds back anonymized analytics information to the party on those who have visited their page. Now you know. Now you've understood the entire scenario. So in this particular example, if you see, the party and the social media platforms are both joint controllers. Get it? Because they are processing the data. They both have a role in deciding the purpose and the manner of processing the personal data. It is all left to them, right? Because they are the ones handling the data. Now, the campaign group decides on the overall purpose of the processing of the data and ultimately chooses to set up a page on the platform which encourages processing of personal data. Now, the social media platform decides on the purpose to help tailor what it created a cookie for. What exactly? Advertising services and provide analytics to the campaign group. So therefore, this was the purpose and the aim for setting up such a platform, right? So now here, it also decides what personal data it processes from the cookie and the manner in which the processing is to take place. Now, both political party and the social media platform, they must ensure that they process personal data in accordance with what? The UK's GDPR, in particular, providing appropriate privacy information. If the cookie has collected a particular information and that particular information is being used by the controller, the same will have to be informed to the data fiduciary, is what the UK GDPR states. Right? I'm sure you've understood what this is all about. Now, quickly talking about Canada. How is Canada addressing it? Now, it's quite different. See, the processing of public information is quite different and I must say very restrictive as well. Right? So here they call it PIPEDA. Okay, so here, which is nothing but, just the previous slide, Mitakshara, please. PIPEDA, the previous one. So here, okay, so if you can see here, yeah, so here it says what? Personal Information Protection and Electronic Documents Act, right? So you get it. So this private organizations in Canada, they find it very challenging. I'll tell you why. Very simple. To understand that personal information that is available in public domain is not necessarily publicly available information under this particular act. Now, here they have clear differences as to what amounts to publicly available data and what does not amount to publicly available data, even if such personal information is put out in the public domain. They've made such a differentiation. So, as per one of the provisions under this particular act, allows the organizations, among other exceptions, to collect personal information without the consent of the individual if the information is publicly available and specified by the regulation. They draw categories. There is a categorization of publicly available information, seems to be out of touch with the current reality and the ease of posting it. And anybody out there can make use of such publicly available data. Right now, as archaic it might sound, this particular categorization, this might be the Office of the Privacy Commissioner, if you see, has actually maintained that public information which does not fall within this category would require the consent of the individual. So they draw categories as such, right? So this is to do with GDPR, EU, GDPR UK, and then Canada. And if you look into US, there is no GDPR US equivalent at the federal level. Maybe individual states, like say for example California, have implemented similar policies as such. So we've only looked deeply into Canada, UK, and the EU, along with India's DPDP A of 2023. Now, yeah, I have done my part in explaining as to what
I
this
think
is.
we really like overshot the time, but
Yeah.
I'm getting messages. But I'll just quickly address the two issues and then we can close. Chandra, I'm so sorry we've like really shot up the time. But to just answer Lavanya and Kavya quickly, so the DNT aspect that you have asked, that's a very interesting feature. But know that this is only voluntarily. So basically, the websites can take that signal that you do not want your data to be used. However, there is no legislation which governs it. There is no sanction which will be imposed if the website chooses to ignore your signal, right? So it does only so much, and it depends on the ethics of that app or the AI platform, whether it really takes up that DNT signal and really refrains from using your data as data set, right? And also, to what extent does that protect your data from web scraping is something that still remains a question. And I think there was another question for me that I had left out, which was regarding the mail interpretation. So I think I already showed you a screenshot of how Google has been sued for web scraping Gmail. So essentially that would include all your inventions that you're perhaps discussing online over email, or the working research on the documents or on any inventions, right? So this really does pose a question as to what publicly available would mean, right, when it comes to web scraping or these AIs which are completely intrusive, right? So I hope you guys, and of course, Lognayaki gave a really elaborate explanation of all the comparative jurisdictions and also anonymization, and of course, and the challenges that have been posed. So I hope you all have a brief idea and introduction to what generative AI is, and to what extent it can be regulated. And yeah, I think there's another quick query that I'll take. Will AI usage be regulated under DPDP Act with amendments, or it will come under Digital India Act? So again, I think both Lognayaki and I discussed this briefly as to how DPDP Act or be it Digital India Act, they all envisage a model which is just imperfect for generative AI. Because firstly, I think the legislature or the government in general, or rather the board itself, is really unaware of what generative AI does, right? So this consent model is very imperfect for something like a generative AI, where I can give consent once, but how it will transform and how the data would eventually turn out or be misused is something that we cannot fathom. And so what I could suggest is that we perhaps should have a board like we have for gaming, where the companies and the ministries have come together and constructed something called a self-regulatory body under the bill or the regulations that have come in for gaming, and something like this could be done for AI. And then a self-regulatory, it could start with the self-regulation of these companies and eventually lead to a legislation that could impose more sanctions and more responsibilities um, on the companies. Yeah, I think it's a EU question, Loga, so you can take that.
Sorry?
I think there's a question on EU law, the EU AI.
Okay, so when we talk about EU has not specifically or explicitly mentioned about the publicly available data. I guess we will have to wait and watch for certain amendments to be brought in EU AI Act as well, because there are certain amendments which are being proposed, right? So I do not know over a period of time. I cannot state.
And I think like that's what requires like another whole lot of lecture, because
Right.
the EU AI Act, the detailed form of it is yet to be read into, yet to be analyzed. And I think, of course, these are parameters that we have discussed in today's session that need to be analyzed from the perspective of EU AI Act. And hence, I think what we are working on is two things. One are the IP violations and going deeper into it, analyzing more case laws based on the comparative analysis. And of course, the second is the EU AI Act and whether that is really doing justice to what it really seems to do.
Right, because when we talk about EU AI Act, because it only speaks about the creating a unified AI market while ensuring ethical and safe AI usage, because they categorize between high risk and low risk applications. So, it mandates human oversight, or be it in terms of transparency or accountability or data quality. I guess we will have to wait and see how they handle publicly available data. So all this is not very expressly mentioned, except on how they cover high risk and low risk applications. We'll have to, I guess, wait and watch.
Ma'am, there is another question in the question tab. It says by Nilab Singh is asking, will DPDP Act inculcate right to be informed with time after its provisional vulnerability regarding publicly available data? Is there also a scope of formation of the review committee to analyze the broader prospects of the act with the right to be informed by the central government?
So I think here, I think we've done the same in gaming industry recently with the Ministry of basically MITI, the Information and Technology. So what generally government is now doing is when they are venturing into such fields like gaming, AI, where they're not really sound to build or to make such amendments in the DPDP Act or in the gaming. When it came to the gaming, there was no legislation really to fit it into. So what governments are doing is they are creating committees where there are not only stakeholders involved from the field, like gaming companies and their representative, but there are also legislative aides of MPs and also the ministry stakeholders. When they all come together, they really have an informed understanding of how the gaming industry works. And I think the same could be done and replicated for AI. So there could be stakeholders, AI startups coming in with the ministry to understand what are the disadvantages or the dangers, and how could regulations be made to at least impose sanctions on these companies. But could DPDP Act really be changed or amended? That's a big question, because that would really change the entire fabric of the act, which is based on a very consent-based model.
More of a conventional consent model.
Correct.
Right, so.
I think there's another question. Loga will take this last question.
I'm not able to view any questions.
So is DPDP Act, I think since you talked about DPIA, is DPDP Act talking about conducting DPI as a mandatory condition.
Yeah, DPI is right. So even for the DPDP Act, we will have to wait because it is still in its nascent stage, and people are trying their level best to see how it can be executed and how one will have to comply with the act. So it's still in its very early stages, where that cannot be answered only after a period of time or so, right? And how the companies have taken it, how the data fiduciaries handle the data, and how the entire board is set up, and what kind of discussions take place in the board. That still has not happened. So that needs to be given a little time for us to.
I mean, there's just so much. I mean, we have so many issues with the DPDP Act itself when it comes to private data or personal data. I mean, I don't know how much justice it will do to that, let alone AI. So AI is another animal altogether that needs to be addressed. So yeah, I think yeah, we still have managed a strength of 150 by the end of this, so, which is 1.5 hours, which is amazing. So that's really great. And I hope you
Yeah.
all got something out of this and understood what we committed.
And yes, if
Thanks
there
a
are
lot,
no more
ma'am.
questions, then the joint convener will give the vote of thanks.
Yeah, thanks a lot, ma'am, on the behalf of Law Tech Society. It was actually a very wonderful and insightful lecture. I'm sure all the attendees would have really enjoyed the lecture. And we really look forward to the collaboration as well as organizing more such events and conferences in the future. Thanks a lot.
Thank you so much. Thank you so much, Srinjoy. Thank you, everybody, for joining and sort of holding on after 1.5 hours. And yes, we look forward to more interaction with you all. Hopefully in person. I'm happy to come by, considering that the interactions that you can have physically is another, I think, experience altogether, and meet you all. And of course, through internships as well, which we will float very soon. And yes, thank you so much, everybody.
Thank you,
Thank you
ma'am.
all. Thank you,
Yeah.
Srinjoy and Kushi,
Mm.
for setting all this up. And I thank all the participants as well. And we look forward to more such fruitful discussions. And like the collaboration says, the objective itself says, for more joint conferences or webinars or internships or joint publications, we're looking forward to it as well. Yeah. Thank you. Thank you all.
Thank you.
Thanks.
All right, then we'll end the session. Thank you.